Hello, I'm Dan Marr, an attorney here at Hamblett Kerrigan in Nashua, New Hampshire. I've been practicing law here in New Hampshire for approximately 36 years and in the Commonwealth of Massachusetts for approximately 28 years. And during that period of time, I've gone helping clients try to collect debts from other businesses, one business client to another. And in today's vlog, I'm going to be talking about how to get, when you can get your debt repaid by the owners of the company. Obviously, if the company that you're trying to collect from has the ability to pay the money, then you don't have these issues. But sometimes you have issues with the reason they're not paying is because the company itself is insolvent. There's a variety of ways that you sometimes are able to get to the owner of the company. Generally, when a company is created with an LLC or a corporation, the idea is when they sign contracts in their capacity as the manager or member of the LLC or the president or some other officer of the corporation, you can only go after the assets of the corporation because you know you're getting into that. That's different than situations like in torts where there's negligence or somebody committed fraud, intentional tort. In that situation, that person themselves did the bad act and you didn't agree to work with him or her in their representative capacity of the corporation. So if they committed fraud to you or they hit you in the crosswalk while they were doing company business, then you generally can go after those people individually in addition to the company. In that situation with the torts, if they're what's called unintentional torts, like by way of example, hitting somebody in the crosswalk while you're doing business, there should be a commercial automobile policy or the person's own auto insurance to deal with that. Intentional torts such as fraud generally are excluded from the insurance policy, so you are thinking about going after the assets of that individual in addition to the company if they're acting as an agent for the company when they're committing these frauds. So in that situation, you can go after the person individually for that. If you're in a situation where the person is the owner of the company and they're using their company to pay all their normal debts and they're making themselves their company insolvent because they're paying their debts. By way of example, while the company's not doing well, they're still paying for their mortgage to the company or they're paying for other personal expenses of the company and they're significant enough to make it worth your while to go after. Then in that situation, you can do what's called piercing the corporate veil. And it's also for the LLC veil. You can do the same in New Hampshire. You can pierce that and go after the assets of the individual because they're really using the company as kind of a fraud in the court's eyes. So if they're not following the regularities and they're actually using the company checkbook as their own personal checkbook, then you can generally, you have to go through a process, but I've done this, pierce the corporate or the LLC veil. You could also be in a situation, the more simpler situation is they're insolvent and they're still taking distributions. So they're taking, while the company is insolvent, you can, if you get access to their K-1s or you see the bank account statement, you see distributions being made to them. And then the question comes down to, are they getting a distribution because of income for work that they're providing? And they're saying, for the company to survive, me being the president of the company, no other company president you could get for $100,000, and I'm taking $100,000 out of this company to keep this company alive, that could be a decent argument. But if they're taking above that amount, or they're taking distributions for equity distributions while the company's not doing well, you can go after those distributions, both in an LLC or a corporation. And also, here's one situation that people don't think about as much. The person put in, say, $500,000 into the company, the owner of the company. The company's not doing well, and they take half of that back. They only get paid $250,000 or say $300,000 for the sake of this discussion, $300,000. So they're still owed $200,000, and that $500,000 that they paid in was legitimate debt. They even signed a promissory note, maybe with a fellow partner or anything else. It's no question that's a legitimate debt. There's something called the Uniform Fraudulent Transfer Act in New Hampshire, and it's a uniform. They really should have been calling it, and they've talked about this, the Uniform Avoidable Transfer Act, because there's a lot of things in there that are not actual fraud. And in this situation, it's not fraud. The person has a legitimate debt, they're an insider, and they pay themselves before the general creditors. So you're a general creditor, and you find out that this person paid themselves $300,000 of their $500,000, so they're still owed $200,000, and you're only owed $100,000. So he's saying, look, I got $200,000 still owed to me, and you only have $100,000. You can go after that to the extent of your $100,000. You can go after that $300,000 that he paid himself. Very important. I've dealt with these issues. Happy to help you. This is Attorney Dan Marr at Hamblett Kerrigan. Our telephone number is 603-883-5501, 603-883-5501, or you can check out our website, NashuaLaw.com. That's NashuaLaw.com. My radio shows should be accessible there from December of 2014 to March of 2023. I've been doing these vlogs regularly, so there's quite a bit of these vlogs available also on the website and on YouTube. Please check out our website. It's useful. And again, I'm Dan Marr, 883-5501, and I'm happy to talk to you. Look forward to talking to you if the opportunity arises. Thank you.